Good morning, Your Honors. William Connolly for the Commonwealth. Your Honors, the single justice in this case had a case before her in which the Commonwealth was ordered to disclose the location of a witness in the Witness Protection Program when it did not know whether or not that particular person...
File it with the court under seal. It's not exactly disclose it.
Well, it is disclosure, Your Honor, because who knows what happens to something once it is in the clerk's office. I'm not saying that there's cast any dispersion in the clerk's office, but it is in fact disclosure. It cannot be any guarantee of it never seeing the light of day, and that's a danger to the
So is it your argument that if someone in witness protection, the defense can never subpoena that person?
That's not correct, Your Honor. In this case, unfortunately, Judge McGuire, and I said put the cart before the horse. Had he denied the Commonwealth's renewed motion to strike, and had he allowed the motion for issuance of the summons, I can represent to the court that the Commonwealth would produce that witness for the suppression hearing. I can represent that to my brother. However, the Commonwealth was being asked to disclose the location of the person. That's not the point. If the point is to get the person to the hearing, the Commonwealth was prepared to do that had the judge ordered made those two rulings. He did not. So now they...
Was that told to the judge? Did you tell the judge, you don't need to do this? If you decide that you want her, we commit to providing her, and if we don't, you can sanction us for failure to do so.
I don't know what the transcript below, what the hearing indicated, Your Honor, but that I'm making that representation to the court.
Without a summons, there's not much the judge can do if she doesn't appear, right? I mean, he can sanction your office, but he can't do much to the witness.
Well, the witness is obligated to cooperate under the memorandum of understanding. Is obligated to cooperate with the office.
With you.
And we would produce the witness had the judge basically ordered us to do so. However, that was not, and this is bringing into the fact that there's a statute, Chapter 263A, which gives the Commonwealth the substantive right not to disclose. So that, not to disclose the location of the witness. So that's the problem, that they're being forced to disclose the location of the witness before ruling that witness is even to be a witness, because there had been no ruling on whether or not there was even going to be a suppression hearing. That was the renewed motion by the Commonwealth. So the single justice was faced with this cart before the horse argument, as well as the statute which the lower court, Judge McGuire, did not have the right to force the Commonwealth to disclose the location of that witness. And failing to recognize that the judge did not have the right to disclose the location of the witness, as well as, I say, the cart before the horse argument, we submit was an abuse of discretion worthy of this court's consideration of the merits, if you will, and that is that the Commonwealth not be forced to disclose the location of the witness under the statute, as well as the regulation. I know the regulation talks about information with regard to, that's 501 CMR 1013 and 14. Talks about the defendant finding information out for the witness protection services, but in that regulation is a specific prohibition of disclosure of any information dealing with the location of the witness. And that's what's at core here. We promise our witnesses we're not going to disclose their addresses. But if we're asked to produce the witness or ordered to produce the witness at a hearing, we will produce them. They are obligated to comply with the agreement. So the point is not whether or not the attendance of the witness was necessary. That is still the subject of the
But was there any suggestion that there was another reason why Judge McGuire wanted the location other than to ensure service of process?
Well, I can only speculate, Your Honor, but it was perhaps, and I'll speculate, this is probably the 6th or 7th time that the matter had been scheduled for argument. He may have been frustrated, frankly. And
I could see why.
Well, that may be so, but I'm speculating that might be a reason. But unfortunately, had he ruled against the Commonwealth, if you will, on both those motions before, then we would have produced it. We would have produced a witness. So that's what.
Find that the single justice, we should give extraordinary relief because you say that she's done something that requires extraordinary relief because he didn't put the cart before the horse, and she just said...
He did put the cart before the horse. She failed to recognize that, as well as she failed to recognized that he had no authority to order the Commonwealth to disclose the location of the witness under the statute, and I'll throw in the regulation as well. So her failure to recognize that the judge had no authority to do so, as well as the fact that she impliedly approved of the conduct of the judge, ordering conduct, the copy for the horse argument, ordering conduct of a party, namely the Commonwealth, to produce the address, the location of the witness, before that conduct was even deemed necessary. It's still before the lower court, Judge McGuire, whether or not there's even going to be a hearing.
Well, the hearing was scheduled for the next day.
No, there is
Scheduled
no
a hearing.
stayed. There was no
I'm reading from
ruling
the
on
judge's
hearing.
order. The
Both matters are
motion
under
is now
advisement.
scheduled for hearing tomorrow.
No.
He issues the order to say, I want the address because there's a hearing scheduled tomorrow.
No. He had not ruled on the Commonwealth's motion to renew, Commonwealth's renewed motion as to whether or not there's even going to be a hearing. So he had two motions, which are still.
So we should view the
still
judge
pending.
to be clearly erroneous when he says the motion is scheduled for hearing tomorrow? It wasn't scheduled for hearing tomorrow?
If he should allow, I think it's.
You don't
if
think
he-
it's implicit in there?
Your Honor, the point is, had he made those rulings against the Commonwealth, we would have produced the witness.
But I mean, the problem I
period.
see here is, it's one thing if you're saying, Judge, we'll get her, we'll have her here, okay? We'll have her here. We will do it. Please don't give the address up. We'll bring her in. So she'll be here tomorrow if you make that decision. You didn't do that. You just kept filing objections and objections. So now you come to us and say you're willing to do that, but that's not what you presented the judge with.
Well, the judge ordered before he was ruled, the judge ordered that we disclose that information. So, and we filed an objection saying he had no right to do so. That's an objection to the court's issuance of that order. That was filed on October 6th. And the same grounds that we're raising here today, namely the statute which prohibits the judge from ordering the Commonwealth to disclose it because the Commonwealth can refuse to disclose the location. It's all, unfortunately, unnecessary because had the judge ordered, number one, denied the Commonwealth's motion.
It's unnecessary because you didn't do what your office could have done and said, we will guarantee that she'll be here. Please don't require us to surrender the address. We'll get her here. But you never said that to the judge. You never gave the judge that option.
I can't speak for the transcript, but I can speak on.
Well, we have to deal with the record before us, and there's nothing in the record to indicate that what you say you offering to us was offered to the judge below. Is there?
No, there's nothing in the record. No.
How can we say the judge abused his discretion when he didn't have the option which you said is so important that you're going to tell it to us here today?
Because the statute said he's not permitted to.
But don't we have to work together? What's really going on down there?
Well, it's unfortunate that it came in that cart before the horse scenario. I agree.
Like a pissing contest between your office and the judge.
Well, I don't know the history. All I can, Your Honor, is just that it came to that point where I refer to, once again, the cart before the horse, and that shouldn't have happened. It was unnecessary. Unless there's any further questions. Oh, just right before, on the same vein, some of the arguments raised by my brother, so the constitutional rights of the Sixth Amendment, again, that would not come into play because the Commonwealth would produce if the judge denies the two motions, allows motions for the issuance of summons and denies the Commonwealth's motion to strike.
So you wouldn't take another 211-3 appeal?
Just as a matter of curiosity, and I don't think I completely heard what you just said, if we were to agree with you, and Mr. Onek was going to file a motion to ask that the witness be required to be produced at the hearing or the trial, what would your position be?
If we ordered to produce her, we would produce her. And she's obligated to comply. So she's under a contractual obligation to comply with proceedings, to attend proceedings. And we will produce her. Unless there's any further questions, the Commonwealth will rest on its brief. Okay.
May it please the court, good afternoon, Your Honors. I'm Peter Onek for Jordan Platt. Your Honors, there are a couple of worrisome things here that I must respond to. My brother says that the Commonwealth would produce the witness. That is not what they say in the brief. My brother's brief says, in the event that her attendance, this is at page 11, in the event that her attendance at a suppression hearing is ultimately compelled, the Commonwealth is prepared to attempt to serve her and to attempt to provide for her attendance at any suppression hearing. And as I write in my brief, the locution is sort of odd. What do they mean by attempt to serve her? Here he says, she'll be there, we'll produce her. But in the brief, they say they will attempt.
I don't remember factually, if you could help me out, whose jurisdiction is the witness protection agreement with?
Bristol County.
It is
They're in Bristol County's?
Bristol County, yes. It's the Bristol County District Attorney's Office.
So they're going to attempt to, with themselves?
Well, they will attempt. I don't know what attempt means. It's an odd, as I put it in my brief, an odd thing to say. It may be just, a careless use of language or whatever. Or does I speculate because I don't know. But I wonder aloud in my brief, is there perhaps a lack of confidence that they have the power to produce her? Has something happened on that front such that? I don't know. I mean, why would they say such a thing? And then, compounding that oddity is the footnote attached to that paragraph in my brother's brief. By stating this, he says, the Commonwealth is not waiving its right to seek appropriate relief from any lower court, allowing the defendant's motion for her summons or from the denial of the Commonwealth's renewed motion to strike. That gets to your question, Justice Botsford. You began to ask, well, are you going to be up here again on another 211.3? That is our concern, that one could have serial 211.3s. Let's say you order the address be produced, or you say that the single justice didn't abuse her discretion, so the address has to be produced. So then the judge allows the motion for summons, to which the address is attached, to be sent to the witness. Well, presumably the district attorney could come up on a 211.3 to oppose to challenge the issuance of the allowance of the motion to summons. And the same thing with their motion to strike the motion to suppress. Suppose the judge goes ahead and denies their motion to strike. They could come up again. So we could have these serial proceedings. Your Honors, it's already over 2 years that my client has been in jail. This is becoming very unseemly in a due process.
I guess what's troubling to me is that this is sort of not. I mean, the government does have a legitimate reason to be protecting a person who they've given witness protection to.
Yes.
And I can understand the concern about not having to trust even a trusted court clerk with an address where they lose a little bit of control over that issue. They can't assure her that no one knows her address because now the judge will and the clerk will, and it means that they're vulnerable. But it does seem as if there's a better way to do this here that would enable them to protect her address and yet deliver her. Is that meaning? I just worry here about. I mean, there is a sensible way to resolve this, but it does not appear to have been followed below.
Well, Your Honor, I think the judge did a pretty good job in exercising his discretion. He recognized the worry about security and so forth, so he ordered that the defense doesn't get the address, the defendant doesn't get the address, the defendant's attorney doesn't get the address, the judge's clerk gets the address. I think that's about as good a balancing as the judge could have done. I think that was a pretty good job of exercising his discretion, and I think the single justice of this court.
In the absence of what Justice Gant said before, which is in the absence of a commitment by the district attorney that they would produce her.
But there was no flat commitment, nor was there one in their brief.
Is this for trial?
Pardon?
For trial for a
It's
hearing.
for motion to suppress.
It's just for the suppression hearing. Your Honor, this is 2 years in, and we haven't even had a suppression hearing yet.
So if the hearing were scheduled, and we were to say that something along the lines that they would either have to produce the witness at the hearing or supply the clerk with the witness's address within 30 days before the hearing, you might be satisfied.
Something like that, something to please ensure that this suppression hearing can go forward. This case is stopped at a very, very early stage.
Well, I think
Already
the
2 years.
District Attorney, I agree with you, but I think that your brother would say, wait a minute, the judge hasn't ruled on the renewed motion to strike the whatever.
Well, let me just say about that an identical motion to strike was filed before Judge McGuire 6 months prior to the filing of this most recent one and was denied, and no appeal was sought by the Commonwealth. Judge McGuire is under no obligation whatsoever to even address that motion. It's way past the 30-day period for a reconsideration of that motion. Implicitly, Judge McGuire is going to deny that motion to strike. He already denied the identical motion 6 months before. And I think it's perfectly implicit that he's going to allow the motion for the summons. That's why he wants the address. In fact, he says, because the Commonwealth has not provided the court with Ms. Cruz's address, the court cannot issue a summons for her attendance at the suppression hearing. So these things are meant to happen. The question is, when the judge allows the motion for a summons and denies the Commonwealth's motion to strike, what's going to happen? What's going to happen? Who's going to act to see that this suppression hearing actually occurs? If I may also address the cart before the horse issue, which my brother places considerable emphasis on. As I say in my brief, that was not raised before the single justice of this court. That is newly before you. The single justice was not presented with any cart before the horse argument. As my brother properly says, the single justice of this court failed to recognize that. In other words, it was never presented to her directly. My brother would impose on the single justice of this court the obligation in a discretionary matter, the obligation to discern issues. That's not what 211.3 is about, and it's not what abuse of discretion standard is about in this court. Another locution he used was, she impliedly approved. So he's being careful not to, he's acknowledging by that language that the single justice was never actually presented with any cart before the horse argument. He's just saying she really should have noticed the order in which these things were happening, and it's an abuse of discretion not to notice that which has not actually been put before her as an argument. That's not a proper abuse of discretion argument, Your Honors. I would also like to mention that you'll find, I believe, before you a defendant's motion to partially lift the stay of trial court proceedings in this case. That was filed 6 weeks ago. It was filed mistakenly in the full court. It should have been filed in the county court across the hall. And 2 weeks later, about a month ago, it was filed in the county court and acted upon by the single justice, and she denied it. So if you find it before you, it's not anything that requires any resolution by you. It's interesting, though, that the existence of that motion illuminates this matter in this way. The reason that trial counsel filed that motion 6 weeks ago, by the way, that was before we knew that this oral argument would be happening so quickly. The reason that she filed it was of this concern that time is passing. 2 years have passed. In other words, the motion to partially lift the stay was meant to release the judge below to at least act on the Commonwealth's motion to strike, the motion to suppress. In other words, at least get that started, because if what we're looking at here is the possibility of serial 211.3s going on for years and years here, at least get that one started. You see? In other words, let's say this one takes a few more months to decide. At least get the proceedings started on that one so that it's running a little bit concurrently with this matter of the address. Otherwise, you're going to have literally serial proceedings. This could be, how many years in are we going to be before a trial can happen in this case? It's very, very worrisome. So that is our position. The narrow answer, I think, to their appeal is that the single justice of this court did not abuse her discretion. She properly exercised her discretion in essentially recognizing that the judge below had properly exercised his discretion in balancing the matter of the address, ordering that it be produced under seal just to the clerk. I think that was a good exercise of his discretion, and the single justice of this court properly exercised her discretion in recognizing that.
Thank you.
Thank you, counsel.
Thank you. Thank you, Your Honor.
All right.